Sir?
Assuming you did have a constitutional convention, how would delegates get elected to represent at that constitutional convention, and would that become political? Would they vote in a general election to be a delegate, or would that be a piggyback onto a partisan election here, like you have with Democrats, Republicans, or could you cross over? I mean, what kind of a game would it be?
That's a great question.
I believe that the provision in the Ohio Constitution dealing with conventions calls for the delegates to be elected in a nonpartisan fashion. That is, they would not be, their party affiliation would not be listed on the ballot. I'm not sure that the Constitution provides much more detail about how the delegates would be apportioned from around the state and things like that.
If it doesn't, then one portion of the state can control the rest of the state.
Well, I'm not sure that that's right. I mean, it seems to me that that there would be powerful political incentives, even if the federal Constitution doesn't, the limitation or the requirements of one person, one vote might not apply strictly in this setting. And I'm not sure about that, but even if they don't, my hunch is that there would be powerful political incentives to have a reasonably representative apportionment of delegates from around the state. And to the extent that that didn't happen, I think it would put the work of the convention under a cloud, because then critics would say, why should we trust the work of some outfit that has basically been controlled by one faction?
I agree. I just checked the text, and Jonathan is correct. The Constitution calls for a nonpartisan ballot for the election of delegates. Although I thought it was interesting, it was probably a different provision that applied in 1912, but the breakdown in 1912 was 62 Democrats, 52 Republicans, 3 independents, and two socialists. So there were party designations, at least there was a party awareness, but I'm not sure if they ran on those tickets or not. Largely, the General Assembly will control the details. The number of delegates, I think, is the same as the number of seats in the General Assembly. Beyond that, open season.
Yeah. Hi. Over the last over the last decades, we've had this education crisis between the governor and the legislature over education funding. And I wonder if you thought that that problem illustrates a particular problem with either the Constitution or the amendment process or the initiative process that might be addressed in this through some sort of convention.
Well, I don't think it's the initiative process. I think it's a political issue. I mean, the Ohio Supreme Court construed some very general language as imposing mandates, and they went back and forth and interpreted and reinterpreted, and there was a real political, legal struggle. I don't know that there's a simple constitutional answer. To be sure, a constitutional provision, if it had support, could, for example, remove the role of the property tax in funding education. But, I mean, that's not a simple matter. It may be a simple matter to draft, but politically that's a very tough issue. I think it's essentially a heavy political issue with some legal overtones.
And I think that it's important to keep in mind that part of the reason that we are in this awkward place is because all of the rulings from the Ohio Supreme Court in the Durolf case, before the court divested itself of jurisdiction, were 4-3 decisions. And I think the reason the court divested itself of jurisdiction was because there was about to be a flip of control of the court, and the 4 justices in the earlier majority, I think, were concerned that with the change that the new majority might simply overrule everything that they had done. Courts don't have all that much power, right? And they have to rely on other political actors and other institutions of government. As Steve said, school funding has essentially been a political challenge, and there hasn't been sufficient consensus or sufficient agreement to bring about truly fundamental changes. And I think unless we have that kind of sense outside the judiciary, what the court does is likely to have only limited impact.
But take it even a step further. It's not the kind of issue that easily lends itself to an initiative petition, for example. There's no deliberative process. Some people draft the petition, get signatures, and then it's a take it or leave it. It's raw politics. So that's the kind of an issue which I would think would not work particularly well as an initiated amendment.
Jonathan, you anticipated my question in a stunning manner. It is, the courts may be in a position to, in some ways, hijack a constitution. I wonder, other than DeRolf, can you cite instances where there have been sharp turns in court approaches, similar to what occurs in Ohio with tort reform from time to time? And then a second question, I'm curious on the white male voter qualification, whether there were any public arguments on that issue and what they might have been on both sides.
Well, I'll defer to Steve on the history in Ohio on quick shifts, but in many ways, the changes back and forth on issues that you mentioned in tort reform in Ohio, we've seen in some other states. The Alabama Supreme Court, for example, since the early 1990s, has gone back and forth on the validity under the state constitution of mandatory arbitration clauses in various sorts of consumer and other contracts. And apparently what happens is, in every election cycle for several running, whichever side had lost in the state Supreme Court by a narrow margin, took out, threw everything they had into it, and they managed to flip the court by one, which then came and overruled what the previous court had done, and then the other side would come back and do the same thing, and so there was tremendous instability there. There's also been a really remarkable development in Michigan over the last 10 or 15 years. The Michigan Supreme Court had been a relatively liberal court for a long time, and sometime in the mid to late 90s, a Republican majority got onto the court. That Republican majority, and I have not followed this in close detail, but I know that that majority undid a lot of precedent in Michigan, and over the last couple of years, where the composition of the court has swung a little bit back, the new majority has begun to repudiate some of the handiwork of the earlier one, but in so doing, the remaining members of that more conservative group have been howling about the demise of the rule of law. It's almost comical to see these two sides claiming that the other side is totally result-oriented. It may well be that both sides are totally result-oriented, but I think that we may expect to see more of that around the country because most states elect their judiciary. Ohio has been one of the frontline states on that. If you remember the 2000 election with some of the really over-the-top attacks on Justice Alice Roby Resnick, she wound up getting reelected by a comfortable margin, but the attacks were sufficiently over the top that Justice Deborah Cook, then Justice Deborah Cook, who was expected to have no difficulty getting reelected because she was kind of a bystander, she almost lost because the folks supporting Roby Resnick went out and really made a major push. But the costs of judicial elections have gone up.